Hello, everyone. Good morning and welcome to today's webinar, 55 Plus Communities and Their Unique Challenges. Before we get started, I would like to go over a few items so you know how to participate in today's event. You have joined the presentation listening using your computer's speaker system by default. If you would prefer to join over the telephone, just select Telephone in the audio pane and the dial-in information will be displayed. All attendees are in listen-only mode. You will have the opportunity to submit text questions to today's presenters by typing your questions into the questions pane of the control panel. You may send in your questions at any time during the presentation. We will collect these and address them throughout the course of the presentation as time allows. Today's webinar is being recorded. A copy of the audio recording and PowerPoint slides will be emailed to you within 24 hours of the completion of this live presentation. And without further ado, I would now like to pass the presentation over to Chad and David.
Thank you, Rachel. So my name is Chad Toms. Thank you everyone for joining us this morning. And what we're putting together for this seminar is we've been getting a lot of questions lately about age restricted or 55 plus communities. So we thought we would put together a very short presentation to kind of talk about the nuts and bolts of the law and the practical applications of it. And as Rachel had mentioned in the introduction, please feel free to put questions in the chat. David and I will be watching that as the seminar or the webinar proceeds this morning, and we'll try to answer those questions as we go. And I'll just kind of give us a little bit of a roadmap of what we're going to try to cover today. We're not actually expecting this to be a very long seminar. We think we can probably cover the materials in about half an hour or so, and then depending on how questions go, it may extend that time period. So for a roadmap, here's what we think we're going to do. We're going to give you a brief introduction, the concept of the law, what's the 55 and older community. Then we're going to get a little bit into the weeds. We're going to dig deep into the details of the law. We're going to put some of the provisions of the statute on the screen and walk through some of the requirements. That'll be the boring, the minutia stuff, but it is really kind of what you need to get into. And then we're going to move into like the third segment, which we're going to try to take some of that detailed information, put it into practical applications, meaning how does the rubber meet the road? How can we take what the regulations of the law are and practically use it? What are the steps we should be doing as a community for compliance? And then finally kind of move into the question and answer session. So that's kind of a roadmap for where we want to go this morning. And please do keep in mind, this is for educational purposes only. We've put together this information so that you're aware of and can issue spot and address some issues. Anything that we provide in this webinar should not be considered as legal advice in regards to your particular community. We, of course, encourage you, if you do have specific questions, that you seek out competent legal counsel to assist you in that regard. And so with that, on our introduction and our roadmap, I'm going to introduce David. And David, I understand you kind of put together some statistics for us about 55 plus communities. Give us some of those statistics.
Thanks, Chad. So we thought it would be helpful to compile some information about why we believe that this presentation is necessary for community associations. It's just a fact right now, America is aging. It's estimated that approximately 71.5 Americans will be age 65 and older. As Americans age, housing targeting the aging population will continue to increase, and the issues that are going to be common within 55 and older communities and aging communities are going to become more prevalent as time moves on.
And thanks. So what I wanted to get into next is really start talking about the law. But before I do, if I could just add a little comment to what David was providing about some of the statistics. And this is not a legal piece. This is really just kind of what do I see in my marketplace? And it seems to me in my marketplace, just from a third party's observation, is it really depends on if the builder, your developer, is looking to sell a particular product. And I have a number of developers in the region that I practice in that I think that that's their focus. They focus on building 55 plus communities because they believe that's a product they can sell. So they have a particular home or a particular floor plan that works out very well. So they find geographic areas that they think 55 plus communities will do well, and they focus on it. So what I will see is clusters of communities by the same developers that really kind of focus in that area. So that's just it from a marketing perspective. That's what I'm seeing, and as what I'm seeing is a number of those communities are increasing over time. The number out there. All right, so let's talk about it. You probably often hear the word HOPA, which, just as you know, that's an acronym that stands for Housing for Older Persons Act. But what does the nitty gritty of that really look like from the law? And so the starting point has to actually be the Fair Housing Act. So the Fair Housing Act essentially is part of the Civil Rights Act of 1968, and that was the act that prohibited discrimination in housing based upon race, color, national origin, religion, sex, familial status, and disability. And so as you might imagine, the statute started, in 68, it's been modified several times, it's expanded, it's been addressed over time. But what we want you to focus on for this discussion is familial status. And that's what we've highlighted on this particular slide, because it's that familial status that is the focus of whether or not a community may regulate and continue to limit its occupancy to owners. And I know the distinction is, and David and I were chatting about this as we were putting materials together, is that most of us will often say a community has the ability to discriminate upon age, which would normally be unallowed under the Fair Housing Act. And we wanted to clarify, well, that's not technically true. It's what we all say, and we think that in the practical application, what it looks like. But the truth is, the statute essentially is allowing discrimination based upon familial status, meaning what is someone's status, not necessarily specific to age. All right, so that's our starting point, is the Fair Housing Act. And so what happened is the Fair Housing Act was adopted in the 60s. As you might imagine, there's been a number of issues that would come up over time. One of those was housing that was designated for older persons becoming problematic, meaning were they actually able to continue to allow or preclude individuals under a certain age now that the Fair Housing Act is adopted. So what happens is in 1995, the Housing for Older Persons Act, which is referred to as HOPA, was adopted. And essentially what that does is it goes into the Fair Housing Act and makes modifications to allow for this particular provision. So we call it HOPA, but understand it really is kind of going into the Fair Housing Act and making some modifications to it. And what it does is it provides for an exemption for discrimination based upon familial status, again, not age, so long as 80% or more of the dwelling units in the community are occupied by one person 55 and older. We're going to start to get into some of that detail. What does that look like? But this is the slide where we're talking about, well, what if I'm one of those folks that I want to go and read the law and I want to read the rules? Great, love that. So what we've done is we put at the bottom of this slide where you can find these things. So essentially, the Fair Housing Act can be found at USC, or the corporate, or the United States Code 42, and essentially 3607 is the section where you will find the HOPA provisions. And in addition to that, we've also given you a list for the CFR. So that is the code of the federal regulation. So essentially that's where HUD has taken those regulations, so taken the statute from the FHA and implied regulations. And just so that you know, I have a copy of it that we've gone through and kind of used to prepare those materials. It's only about 10 pages. So if you go and pull the regulations, it would be very helpful. What you'll see is if you do pull the regulations, you'll see an awful lot of what we're going to put into this seminar is kind of the high level materials that we grab from the regulations. And when you start reading through those regulations, what you'll see is the first half of it is an introduction, talking of terms, talking about history, and then the last half of it is actually the regulations that we're going to start to go through. So with that, David, let me kick it back to you and start to get into some of the details of what HOPA is.
Thanks, Chad. And if you do pull the federal regulations, I advise that you do so with a cup of coffee to help keep you stay awake there. But as Chad referenced, what is HOPA? HOPA created this exemption for housing for persons aged 55 or older, so long as certain criteria, certain requirements are met. The first of those requirements is there has to be an intention to operate as a 55 and older community. So first and foremost, you need that intent, and then there's 3 additional requirements that need to be met in order for this exemption to apply. The first of which is at least 80% of the occupied units or properties within a housing community need to be occupied by at least one person who is 55 years of age or older. The key or operative word there is occupied, and we're going to get into each one of these criteria a little bit more in depth as this presentation moves forward. The second criteria that needs to be met is the housing community needs to publish and adhere to policies and procedures that demonstrate the intent to operate as a 55 or older housing community. And then finally, number 3, the housing community must comply with HUD's regulatory requirements for age verification of residents. And those are the regulatory requirements that are put out by the HUD secretary. We've provided a nice link there in case anyone wants to peruse the website themselves. But of course, we're going to go into greater detail with each one of these criteria a little bit later on in the presentation and in the first point immediately.
And stick with us, folks. I know that this is the real heavy code-driven regulation stuff, but it's kind of what we have to get through. So we'll try to make it as interesting as possible. So David, can you go back to the previous slide? So I want to highlight for the folks that choose to get the slides later or watch this after the fact. The way we've set these slides up, so you'll see in the slide that David just went through, there's the bullet points at the bottom, the I, double I, and the triple I. We're now going to go through some slides where we're going to take each one of those and try to break it down into a little bit more detail, just so that you see. So view this slide kind of as your table of content. And now when we move into the next slide, you're going to see, so David, jump to the next slide. So you'll see we've referenced the code section, and you see how it ends with an I, 3607B2CI. So again, if you're following along the regulations, that's where you'll find this. And just, forgive me for all the detail. Again, this is the heavy, meaty stuff, but we wanted to make sure that you kind of had a roadmap. So if you go back and look at this information later and you have a specific question, you'll know where to find it. All right, so I'm going to start to dig into that one first section. And this is essentially, which is the creation of that 80% limit. So I'm sure most everyone on the webinar has heard referenced the 80-20 rule or the 80% occupancy. So let's talk about that. So essentially, one of the regulations requires an occupancy of at least 80%, and I've highlighted that in my notes, at least 80% of the occupied, I've highlighted that in my notes also, units in the property and the housing community must be a person at least of the age of 55 and older. And so before I move on from that, we want to highlight for you at least 80, which means that's the floor. It can be higher, and we're going to have a couple slides later on where we talk about, well, can your governing documents require something more? Yes, they can. This is the floor, and the floor is 80. We can't drop below that floor. And the other thing that we want to highlight for you is occupied. You don't see ownership. So the next point we're making on this slide is this does not require that the home or the unit or condo, depending on what the structure of the community is owned by somebody that is over the age of 55. It's an occupancy requirement. And that's really important because it does allow for estate planning, for passing properties on to children or for various generations to address the ownership. It is about who's actually going to be occupying. And before I move on with this, we haven't actually put a slide to this because we rarely see it in our work, but there's actually some additional exemptions you'll find in the regulations that some communities may choose to skip that 55 threshold and move to the 62-year-old threshold. And then in that case, it's 100% threshold. So I don't want to confuse anybody because I don't think I've really seen it in my jurisdiction, but that is a possibility. So if that's what your community does and that's what your documents require, you probably want to get a little deeper into the regulations on some of those things. So David, let me throw it back to you to take the next slide.
Thanks, Chad. So, Chad kind of referenced the 2 slides ago being the table of contents going through each of the criteria that needs to be met. Chad just went over the first set, which is the 80% rule, if you will. I'm going to go over the second set of criteria, which is the housing community needs to publish and adhere to policies and procedures demonstrating an intent to operate as a 55 or older housing community. You see in that first bulleted point there, 55 or older. in quotation marks. That's important because you can't just say that you're going to operate as an adult community or an adult housing community. We have to really use that language 55 or older. Really goes to demonstrating that intent. Often you'll find language in the association's governing documents. I don't want to say often, you'll always find language in the association's governing documents, declaration, and sometimes bylaws referencing the 55 or older restrictions, and then they're oftentimes supplemented by resolutions. Some factors that are considered when determining whether a housing community has complied with this section or this set of criteria are the manner in which the housing community is described to prospective residents, any advertising designed to attract prospective residents, written rules, regulations, covenants, deed, or other restrictions, maintenance and consistent application of relevant procedures, the actual practices that are taken by the housing community, and posting in the association's common areas statements describing the housing community as housing for persons 55 years of age or older. It's important to note that this is not the entire universe of factors or criteria that's considered when determining whether we've satisfied this second set of criteria that needs to be met, but these are certainly the most common. And with that, I'm going to hand it back over to Chad for the third set of criteria.
Actually, I think the way the slides go, I think I got a little bit more to add on this one before moving on.
Okay.
And this, Dave was covering the age component, and I guess the way I've read the regulations and the comment period that came in when the regulations were being circulated for comment was that there was a lot of comments about what to call these types of communities. For example, adult living, adult community, adult. So what happens is there's a lot of discussion in those comments about what to call it, and I think that the final version wanted to make clear, and it says many times, it doesn't matter. Don't use those statements or those phrases. What's really important is the intent to operate as housing for persons 55 years and older. And so what we take from that is those phrases, while you can use them, don't think that's sufficient. You still have to focus on when you want those magic phrases of the intent to operate as a housing for persons of 55 years or older. So that's the purpose of this slide. And what we also wanted to kind of link to that we take from the regulations is that just because you have the intent to operate as housing for a person that's 55, it doesn't mean that occupancy of others would be a violation. So what that really means is that families and children can still be in that community so long as all of the other requirements are met, including the requirement of intent to be a community for persons 55 and older. And I'll be honest with you, this is where I probably spend the most amount of time in dealing with this for the jurisdiction in which I practice, which is, well, what other people are allowed to live in the community? Are there children? Can there be people that are under the age of 55? What if there's different family members? And that is kind of what drives us often back to the community's governing documents, because remember, what we talked about, HOPA is the floor. It's the minimum that's required to keep the ability to discriminate based upon familial status. It doesn't set the ceiling on who can or can't live there, and that's where your documents come in. We're going to talk about that a little bit later. So I think, David, that brings up you to launch the next one.
And I did jump the gun there. I'm going to pass it back to myself for the third set of criteria, which is the housing community must comply with HUD's requirements for age verification of residents. Really, what the association is going to want to do is send out, surveys to compile information on the ages of residents within the community. It's important, obviously, when you send these records out to keep the records, which we'll get into a little bit longer in terms of record keeping and recommendations to that end. And really the association must develop procedures for determining the occupancy of each unit property. This can be through regular updates or surveys, but you're also going to run into scenarios where residents aren't going to want to provide this information to you, which we'll address as well a little bit later. You run in the scenario where perhaps someone is away, someone doesn't want to provide this information. How can you verify the occupancy, the age of residents living in those units or that property? And with that, I'm going to hand it back over to Chad.
Yeah, so I'll jump into that. So within this category, this is where we start to get into the details of the verification process and the regulations. And again, this was from 1995, I think was the final rule when it was issued, listing what the HUD thought was appropriate. And some of the things that you could collect to prove age is what you might expect: driver's license, birth certificate, passport, immigration card. There's some other ones in there that are interesting, the military identification, and I like the catch-all of other state and local forms that contain a birthday. So I guess that's if your state has something different. But the one that we highlight and that we try to use the most is this certification. So the regulations allow you to accept a certification, a lease application, affidavit, or other document. Here's the trick: signed by any member of the household. It doesn't necessarily have to be the person of age. It has to be anybody in the household age 19 or older, asserting that at least one person in the unit is 55 years of age and older. So as you might imagine, that is an easy avenue for us to create forms. And we're going to talk about that later, that if you choose to use that particular path, how can we develop some forms that will get us where we need to go? And lastly, before we move on from this particular topic, we do want to remind you that the housing community must establish policies that requires the occupant to comply with age verification. So we're going to talk about that later when we get to the practical application. Is what does the policy look like and how do you accomplish these verifications? So David, I think you had a couple more comments on the next slide for this one.
Yes, and I kind of touched on this issue, which is what happens if a unit owner or a resident refuses to respond to an age verification survey. If you have a prior survey that someone has filled out, they haven't moved on from the property, you can use that and you can rely on that survey. You can also rely on verifiable, publicly accessible information, and some examples of that would be government records or documents. For example, local household census. Again, I already touched on it, but a prior age verification form or application, or a statement from an individual with personal knowledge of the age of the occupants. You can rely on all of those information, all of that information. And you'll often see this happen. Someone's on vacation when the survey comes out, or again, they just refuse to or don't want to provide that information to the association for whatever reason.
And I think we've kind of reached the end of that big, heavy, meaty section. We're about to move into the practical application section, right? Am I right, Dave? We're on the next slide, would be 11. Yep,
that's
perfect. So let me pause for a second, because I see a couple questions in the comment that are related to what we've been talking about. So one of the questions was, can a community establish an occupancy rule that forbids anyone under a certain age from living there? And the answer is yes. I think we talked briefly about that in one of the slides before, that you can establish a minimum. I'll tell you the most common one that I see is prohibiting anyone under the age of 18 or 19. And now I will often see with that same language exemptions and waivers and the process by which someone that is a caregiver can reside there. But so the answer to that question is yes. Remember, the law is the floor. What we're going through is the floor, which allows those types of things. Your documents could then layer on top of additional impositions. Let me see. There was another question here. When conducting age surveys, do residents have to prove their age, or can they simply attest to it? Follow-up question: if a resident does not answer the survey, what do we do? And I think that we have that one coming up, right? We're going to cover that one, David, in one of the other slides about how to handle enforcement. But to answer those questions, They don't, one of the slides back, we talked about the typical types of documents that you could accumulate, which would show age and prove age. But then one of those catch-alls was a certification or a verification. So to answer that question, yes, there's a couple options that you have there. All right, so with that, let me kind of introduce this topic. I see a couple of questions rolling into the chat. So we'll do is let me introduce this topic, and I'll give David a chance to jump into his slide, and we'll kind of start looking at some more of the questions as we go, and we'll try to hit them as we go through. And then of course, there'll be time at the end, we can kind of circle back and cover those. So here's where we're going to move into essentially kind of like the third category. We've covered all the heavy stuff. Now we want to talk about, all right, give me some practical applications. I'm the community, I'm the board of directors. What do I need to do to, one, comply with all of these regulations? What does my day in and day out process look like? Well, here's what we've got. We recommend that you adopt policies and procedures and forms for verification of age. Easy for us to say, right? So what does that look like? We typically, and again, this is just the forms we've developed over time. David and I use some of these forms. There's different lawyers in our firm that use different forms. I'm sure there's lawyers in other firms that do it completely different. This is just how we've done it. There's a couple different ways to tackle it, but we typically will encourage an association to adopt a housing policy. And this is a more global policy. It focuses on that intent to be a community for individuals over the age of 55, and it covers all of the policies and the procedures and the rules. And what does it also do? It also would incorporate or say whether or not the association is going to use forms for new sales contracts or approval of new members before they move in. What about leases and tenants? What kind of forms or provisions do we want to see in those documents? Do we want to make it available to people on the front end to make it easier that says use our form versus proving your age? And then of course, there's that periodic update form or survey. So whether or not you want to do updates as they happen or do a survey every 2 years, that's kind of what we think are the practical applications. So then again, view this slide here. This is going to be our index again. So we're going to start to move forward and start to put a slide together, which is a little bit more detail on what we think each one of these could include. So back to you, David.
So the first form or policy that Chad referenced was this housing policy. We recommend creating a comprehensive housing policy that will hopefully address all of the requirements and considerations set forth in HOPA, and also to an extent, I'm going to go back one slide, perhaps even address each and every single one of these items below: the sale contract and approval forms, lease tenant approval forms, and any periodic update forms that can kind of be attached as an appendix or appendices to the housing policy. So the housing policy should explain the occupancy restrictions within your individual association. Should definitely set forth the intent to operate as an age-restricted housing. Use that big language, right here, because there is reference to the 62 and older exemption in addition to the 55 and older exemption. But certainly the exemption that we see more often is the 55 and older housing. The housing policy should also identify, how the association treats the presence of children within the community, provide procedures for verification of occupancy, and process for exceptions to the housing policy. Each association is different. There's no cookie cutter or one size fits all policy. So when you're adopting these policies and also considering the process for any exceptions, it should really be tailored to your specific community and your specific community's needs. With that, I am going to hand this back to Chad.
Sure, and as David was mentioning, the housing policy, I think the one I use, it has a bunch of different attachments to it, just to kind of put it all up in one document. So some of those attachments are what we would consider these new sales or new resident form. And what do we put in those forms? Well, we have consents and waivers, meaning that you're consenting that you're going to be moving into a community that's intended for 55 plus, and you're waiving any arguments that the association is not complying with HOPA, something along those lines. So trying to get that on the front end. It also has an acknowledgement of receipt of the policy, receipt of the rules, We have an age qualification statement. So back to what our discussion was, are we collecting licenses when they close, or are we giving them just an age certification statement? We've often found that the age certification statement is an easier way to go around it. And then lastly, I include a form for updating information so that if the ownership changes or something happens, you have a form readily available for folks to simply just fill it out and on a real-time basis tell the association this is changing, update your records. Instead of having to wait for the survey to come out every couple of years, you're telling the association on the front end. So that's kind of the things I like to do. And again, we're not giving you these practical applications that we do. This is not a requirement. You're not going to find these in the regulations. We're just telling you, think about these things. If I see a question in the chat that says, do I absolutely have to do this? No, these are just what we're recommending is a practical way to try to comply with this from a bookkeeping perspective.
All right, and the lease tenant forms or appendix to that housing policy is going to look eerily similar to the new sales and new resident form. You're going to want the same consent and waiver. You're going to want an acknowledgement of receipt of the policy and the rules within the association. You're going to want to certify the age of the tenant, as well as any additional household members that are going to reside at the property. Again, I kind of breezed through this one because the requirements or what is included is very similar to what's going to be included in the new sales and new residence form. It's just in a different context of if an owner in the community decides to lease their unit out to someone else. I'll hand that back up to Chad.
All right, and that brings us over to, we're going to talk a little bit about where's your language come from? How do you create or modify these restrictions? And then we're going to move into some practical issues, and then hopefully we're into question and answer at that point. So creating and removing age restrictions. The vast majority of communities, you will go to your governing documents, wherever you call them in your state. For me, it's primarily CC&Rs or the declarations where you'll find these. Sometimes it'll be in the bylaws. But let me give you the practical reality. They're not always where you expect them to be. So I have some communities where from the beginning, they've always were intended to be developed as a 55 plus community. It's in the documents, it's all over the place. I have some communities where I guess sales weren't going very well. So the developer thought, well, let's make a section or a phase 55 and older. And I've seen amendments to declarations where they simply carve out a number of lots and say, lots 100 through 200 are now age restricted. And so sometimes it's a little difficult to find those provisions. I've even seen some where after the community has been going for a little while, the developer concludes, well, I'm not selling very well, so let's make it age restricted. They essentially say, well, I've already sold 20% of the community, so they're the 20% non-compliant. All the rest now have to be compliant. So again, there's no one way these happen. You have to go and find your documents. But now, assuming that you've got your documents and you found those restrictions, what happens if you don't like them? What happens if they're too restrictive? What happens if you want to modify them? And you modify those like any other modification to your amending document. You would look to your state law and what your governing documents do is what type of threshold vote is necessary to do it. And sometimes keep in mind, amending that language may very well trigger a mortgagee consent process, depending on whether or not it's one of those provisions that's material in your governing document. So just laying that out there. I've had a number of questions about how do we change this language? We don't like it. It's not practical. It's too restrictive. That's how you would go about doing it.
All right. And at this point of the presentation, we thought it'd be important to identify some common issues in 55 or older communities. And a relatively common issue is reasonable accommodations. Reasonable accommodation is a change in a rule, policy, or service which affords an occupant with a disability an equal opportunity to use their unit or the property of the community. Who is considered an individual with a disability? Someone that has a physical or mental impairment that substantially limits one or more major activities. Included some examples right there to kind of show what types of what types of things can be considered as a disability, and that includes something that you can't see really, which is arthritis, heart disease, mental illness, or hoarding. But it's also important to note that disability can be, physical as well, permanent or transitory, and the reasonable accommodation must be made in a manner to address the permanent or transitory nature of the disability. Some examples of a transitory disability could be, someone with a broken foot or a torn ACL. Request must be made by the owner or occupant. And some examples of a reasonable accommodation include permitting a service animal despite the prohibition of pets within the association, and permitting an occupant to use a handicap parking space, perhaps directly out in front of the building which they reside.
And following along with that, I'm going to take this slide here about reasonable modifications. So just to back up just slightly, David and I could probably spend 3 hours doing a presentation on the Fair Housing Act, reasonable accommodations, reasonable modifications. So please understand what we've put together in these 2 slides is a really high 30,000 foot perspective, but it helps you to identify that reasonable accommodations and reasonable modifications of the Fair Housing Act are always out there. They're always something that you have to be wary of, even when you're dealing with your 55 and older HOPA compliance. These issues of reasonable modification can come into play. So sometimes we have conversations with our clients where we're talking about an enforcement component for an age-restricted community, but we're layering on top of that, well, this may actually be something you're required to do as a reasonable modification or a reasonable accommodation under fair housing. So just wanted to throw that out there. And by the way, I'm seeing a lot of great questions. Hit the chat. We're going to try to get to those as soon as we finish up with the main materials. I think some of them will get answered in what we're going to cover, and then we'll start hitting some of those questions. Thank you very much for everyone submitting those questions. So back to this slide. So David introduced the concept of a reasonable accommodation. I'm going to give you the reasonable modification. And again, we could spend all day talking about the differences, but for the most part, the differences for modification is that it's essentially a change to a physical structure to afford an occupant the opportunity to use and enjoy their property. Now, the real distinction that we make in these slides is that the cost of that is borne by the individual that's seeking the request. And so that's the big difference between changes to the Fair Housing Act versus the ADA, is who's really paying for some of these changes. So we're always going to make sure that you're aware. You may very well be dealing with a number of these issues. We've given you a list of the things to think about, like a ramp, a wheelchair ramp, a bigger doorway, curb cuts within the community. These are the kinds of things that are modifications that an owner may seek to address their disability. And in a 55+ community, I think you should assume you're going to see a proportionately higher amount of these types of requests than a non-55 age-restricted community, simply because your typical members are going to be faced with more of these challenges. So David, let me throw that back to you to talk about some of the community services.
Yeah, so a lot of times you get questions, what types of services does an association have to provide to its members or the residents within the housing community? And the answer to that is generally there's no requirement to provide for any personal care or special care for the needs of any resident within the community. What associations can look to towards to guide them for what requirements they have or what obligations or duties they have to members of the association are their individual governing documents, like Brad referenced, CR's declaration, bylaws, as well as the statutes and the jurisdiction where the community is located to determine what duties, obligations the association has when providing services to the community.
Okay, and I think now we have reached essentially the question and answer session. So David and I put together a couple quick questions that we thought would get the ball rolling, and then we'll kind of get into the ones that we see on the chat. So David, how long should a housing community retain records of survey information that shows it meets or met the 80% requirement?
Yeah, so as long as a housing community intends to maintain that exempt status, it should retain these documents, and you should really think of this in terms of you're enforcing this this restriction, and if you don't have these documents, not only are you going to lose the protection of this exempt status, but you're also opening the association up to potential liability on the back end. So in terms of discrimination or any allegations of discrimination. So it's always important to maintain those records and keep those records and hold on to them for as long as you intend to operate as that 55 or older community or 62 or older community. Now, Chad, may a housing community impose an age limitation that is more restrictive than that required by HOPA and still qualify for the 55 or older exemption?
Well, conveniently, David, you've kindly provided me the answer on the slide. Thank you very much. But I will say this actually probably answers one or two of the questions I do see in the chat. And the answer is yes. So again, the HOPA and the regulations are the floor, the minimum that you must do to be able to continue to discriminate on the basis of familial status. But you can go above and beyond. I've seen some community governing documents that require 100% compliance, that they don't allow that 20% threshold. I've seen prohibitions against children, but I've also seen processes built into governing documents for requests for hardship applications, requests for waivers, requests for exemptions. So, the more complexity you can build into your documents, that's fine. It just depends on how much ability you have to enforce those types of things. So yeah, no problem there. So David, last question on the slide here for you. How are state and federal fair housing laws that prohibit age discrimination impacted by HOPA?
Yeah, and thank you for the question, Chad. And we touched on it a few different times, but HOPA provides an exemption for discrimination based on familial status. It doesn't provide an exemption for discrimination based on age. So it is important to note that the FHA and HOPA do not cover or provide an exemption for that age discrimination, and it's important to take a look at the laws in the jurisdiction where your community is located in.
All right, well, let me start to go through some of the questions that we have in the chat. So I think I answered a couple, so here's one. Does the HUD survey have to be done yearly? David, do you have an answer for that? If not, I've got the regulations here, so we can go through them real quick.
So Chad, I believe it does not need to be done yearly. I believe it has to be done every 2 years. And again, those records should be kept. But feel free to correct me if I got the number wrong there. And I think that kind of touches on a second question that was asked, which was, my 55 plus community has not been diligent about doing the age verification at least once every 2 years. Can we do it in year 3 to catch up and try to be more diligent in the future? I think it would be important to send that survey out as soon as possible. And it really is going to depend on whether or not that would be accepted by HUD, but certainly sending it out sooner rather than later and complying with the spirit of the statute would be important.
Yeah, and as David, as you were answering that, I kind of opened up the regulations. So if you go deep into them in Reg 100.307, subpart C is where it says such updates, that's referring to the survey, must take place at least once every 2 years. So we are going to recommend that you stick to it at least every 2 years. Can you do it every year? Yes, you can, but that's what the regulations are looking for. And again, I've had a couple communities that are really small. Let's say they're only 20 units, and they know everybody who lives in there. Do they actually have to send out the survey form? I've gotten that question before, and I've often said, well, I think that you can build into your housing policy and your procedures that you can deem the survey to have been completed by somebody reviewing the information and making sure that it's accurate. So you have to do something every 2 years to make sure that they're accurate. But again, that's my interpretation of the regulation. So I would say each community is going to turn on its own facts and circumstances and what the nature of your constituent group is. All right, let's see, where were we on the questions? Let's see, if the age verification requirement is contained in the deed restrictions, is a separate community policy still needed? So I guess the way I would answer that question is it absolutely required? No, I think we kind of said that. But what we talked about is that you have to, under the regulations, you have to express an intent. You know, how does a community express an intent? You know, and in the previous to social media, some of the examples given in the regulations were posting signs or making sure that when you entered the community, you knew it was an age-restricted community. So what we have found, and our recommendation has been, is that, well, how can you best express that intent? Well, you can best express that intent in some sort of written policy, and that's why we've landed on recommending the housing policy. But to answer the question the way it was done, I would say no, there's nothing that says thou shalt have a written. I'm sorry. Written all the forms that we had put on our list. Yeah, like we had said, this is just what we're recommending, and not every one of those forms is a requirement. We do recommend that you have to adopt the policies and the procedures. So Dave, anything you want to add to that? I felt like I was stumbling around a little bit and making a real mess of it. Maybe if you want to clean it up, feel free to do so.
Oh, no, and I think the answer was a good answer. And to the extent that when we send this material out, you need to look at any particular slide. It is one of the slides where we're kind of delving a little bit deeper into 3607 B2C double little I. And it really does list relevant factors that are considered. So not any one factor is dispositive of this issue, but certainly the more boxes you check, if you will, is going to help the association's case should HOPA ever be questioned within your community.
All right, let me read another question from the chat box. So, do we have to verify the age if an owner passes away and a family member moves in to take care of the property or sell it? And I think that goes to one of the slides that I had covered, which was focusing on the occupancy. So we are focusing on the occupancy. So if that unit is occupied by somebody that is under the age of 55, yeah, you potentially would put them in that 20% category. That's a non-compliant unit. And I think the question was really focused on, well, do we have to verify the age? And yeah, it comes around with every 2 years on that survey, we are looking for the verification. So hopefully I've answered that question, right? David, anything you want to add to that?
No, I think that was a good answer. I can kind of pull a new question from the queue. So one of the most recent questions in the chat, we recently had a family move in with a child below our minimum age from a resale. How can that be prevented? I'd look at it a little bit differently in the way that I think the question should be, how can the association, seek to enforce, its governing documents and its policies and procedures? You might want to send or think of sending some sort of violation notice if we're dealing with an issue related to that. But it's also important to note some case law out there. Again, we touched on restrictions being more restrictive than the 80% rule, and Chad touched on that. But some courts have looked at this issue and held, well, if we're talking about one family with one child below the minimum age, we haven't made that 80% threshold yet, so we may still allow it. So a long-winded way of saying it depends, but it almost seems a little bit we may need to look at the question differently because the individuals have already moved into the property.
And if I could add into that, go back to one of our other slides, that only one resident has to meet the criteria and then you're compliant. So the way this question was worded, maybe your governing documents impose a higher restriction. But if it was just the HOPA language, the focus is not necessarily there's a child. The focus is there not a resident that meets the criteria? So again, you got to go to your governing documents. They may require something more restrictive. So here's a accommodation request. So one of the questions is, can the board make a reasonable accommodation if it, I'm assuming that just means if the owner that's requesting the accommodation is also in violation of the deed restriction clause. Now, this is really a little bit beyond our HOPA discussion, but it's a little bit of we did have a couple slides on accommodation. So David, you want to take that one?
Oh, I would need to hear the question. I was actually surfing for another question to pull after this one, Chad.
So let me rephrase the question a little bit, which is, if an owner asks for a reasonable accommodation, can we deny it if we think they're in violation of a separate deed restriction?
No, I don't think you can. It's the reasonable accommodation is made that kind of allows the association to look the other way when there is a violation of a rule or a policy or something contained in the association's governing documents. And the most common example, and we have it listed there, was permitting a service animal despite a restriction on having any animals within the association. And it's important to note too, when we're discussing service animals, normally a service animal is designated to help I'm going to look at the specific word here, an occupant with a disability. So receiving that a service animal doesn't allow that individual to have 3 dogs that are helping them out with a specific disability. It is going to be one service animal that applies to that disability.
Let me pull another question here. This one's a little bit specific. So it says, of course, as a new question comes in, it rolls off my screen. If you amend your documents and they're really old, or you amend your rules, can you enforce that change with an existing resident, or are they grandfathered into the rule? So I know we talked about on one of our slides amending your restrictions. So let's say, for example, you just have standard 80-20 language for HOPA, and you want to now impose higher restrictions going forward. Can you do that against current owners? And sadly, I don't think you're going to like my answer really in this case, because it's really going to depend. It's going to depend on the jurisdiction in which you practice, what are the laws in that jurisdiction and the case law, and then your governing documents as to whether or not amendments can be applicable. So where in my jurisdiction, I'm aware of some case law that says that if you purchased under a declaration that had a provision that allowed for it to be amended by less than a unanimous consent, then owners would be stuck with those amendments so long as it met the threshold criteria. But again, you should consult with legal counsel on your specific situation in that question. Let me see, I think we've covered all those except for maybe the new one that just came in. Let's see, the new one that came in looks like it's trying to clarify, if we do not allow anyone under the age of 19, but a family moves in with a younger child, I'm wondering if there are procedures we could have in place to prevent this. And I think this might go to like one of the other questions I saw earlier, which is how do we let realtors know that we're a 55 and older community? So under the pre-social media day, the regulations had something about posting signs, but you're asking a practical application. So this is not really legal issues about how you make sure realtors know. But if you go back to the slide we did on the housing policy, one of those policies is a new owner form and a new owner application and criteria. And what you could do, at least in my jurisdiction, you're required to give resale certificates. So that information could travel with any resale certificate so that a potential owner would receive it and be required to fill it out. So that's one option, but again, there's a lot of different ways that you need to get that information out to owners, and having it in writing as a policy is very helpful. All right, David, did I miss anything? Did you see anything else in there?
I didn't see anything else. I think we might have covered it all. But of course, if you have any additional questions or anything specific that you'd like to address, this last slide, you have Chad's contact information, you have my contact information. Please feel free to reach out, touch base with us, give us a call, shoot us an email. We're happy to field and answer any additional questions you may have.
Thank you, David. And I want to also thank Rachel Marchand, who was kind enough to help set all of this up for us. We couldn't do it without her. So thank you very much, Rachel. I'm going to turn it back over to you to close us out.
Thanks for the shout out, Chad. There were a few questions I'm seeing coming in here last minute, and no worries. We will go ahead and review those and get you answers sent after the webinar. So I want to thank everyone for attending today, our 55 plus communities and their unique challenges webinar. We hope you enjoyed the presentation, and on behalf of all of us here at Whiteford, Taylor and Preston, please stay well.
Thank you.
Thanks, everyone.